I wanted to zero in on a statement just before the conclusion of the article. So page 45, if general law as such is no longer part of the legal system, the possibility that it conflicts with state law does not arise. So, and as I understand your response to Michael McConnell, I don't think you questioned his assumption that general law refers to common law, not statutory law. And I also don't think that you would deny that there's been a substantial change in the balance between common law and statutory law since 1868. And the passages just before the one I quoted seem to me to suggest that you would also not disagree that the conception of general law as standing apart from the decisional law of particular states has withered on the vine, that this is no longer the way that state courts understand their own behavior. So then, doesn't that imply that if general law rights are definitive of privileges or immunities, setting aside the particularly federal rights, that such rights are no longer covered by the privileges or immunities clause? And then, if so, how do you reconcile the anti-discrimination principle with respect to such rights with the non-existence of the rights?
I'm quoting from page 17 of your draft, and this is a point you make several points in the paper. You say the additional assumption is that non-federal law defines some rights and insulates them from state lawmaking power. Whether that assumption is correct is a question of law, not of the meaning of the privileges and immunities of citizens of the United States. So it's a question of law, but whose law and what kind of law? Is it a question of state law? Is it itself a question of unwritten general law? Might it be a question of constitutional law? And if so, what might the originalist answer to it be?
So my question hits at kind of the opposite angle from where Larry was taking it, that if it is the case that these general law rights no longer exist and there are no longer any monsters under the bed, why isn't it the case that if the framers of the 14th Amendment were trying to secure certain kinds of liberties, that maybe some form of modern incorporation is a second best approximation of what we should be doing, rather than just throwing our arms up and saying no rights at all?
First, Larry, I think that the old general common law, for some of the reasons that you just described, which are about what actually happens in the American legal system, and especially when we're talking about something that's not enacted law, that takes the form of a text, we have to ask what is the actual practice of the American legal system? What do state and federal judges do? How do they understand what they are doing? And so I think probably it's gone. I don't think it's there anymore as the old general common law, meaning one that applies to private rights, was private rights as opposed to a few other things. I don't think it's there anymore. I also, but I don't think, and I haven't explained this adequately, I don't think that means that the equality-based reading of the Privileges or Immunities Clause, and does the Privileges or Immunities Clause still, in effect, constitutionalize the Civil Rights Act of 1866, I don't think that falls with it, because I think that whatever is true about rights of general citizenship, that it's also true that the 14th Amendment, including the first sentence of Section 1 of the 14th Amendment, attaches to national citizenship when U.S. citizens become citizens of a state by residence, attaches to that the rights, the privileges and immunities of state citizenship. So even if you think there was never really much in the category of general citizenship, the 14th Amendment picks up state citizenship too, and the concept of abridgment imposes an anti-discrimination requirement with respect to that. And today, yeah, I think probably property and contract and protection by the government and all of that are just rights of state citizenship. And they can't get substantive protection because the argument to substantive protection goes through this idea that they are general citizenship rights, but they do get general equality, anti-discrimination protection. Tom, I wish I knew the answer to that question, but I will say that part of what I'm trying to raise is to ask, how can you answer that question? Is because you say, is it a question of constitutional law? The way I tend to think about the American legal system is that it's got state and national law, and it's got a legal hierarchy, and the hierarchy is established by Article 6, but none of that, well, then anything else is a monster. But here's going to be the answer. Given that the American legal system is the actual practice of the people who participate in the American legal system, if there was or is a practice of private law rights that are insulated from, and you quoted a crucial passage, private law rights that are insulated from the legislative power, the lawmaking power of the states for reasons other than federal law, well, if people, where does law come from? It comes from the practice of legal institutions, lawyers, judges, other parts of the government who are not judges. So, and it's hard to fit that possibility into the standard, fairly simple state and federal hierarchical relationship understanding of the American legal system. And again, one of the things I want to say is, for that possibility to have been real or to be real, the American legal system has to have been or be a little funnier than we normally think it is, and that I thought it was for a long time. As for whether a second best approach would say there has to be, in order to achieve the goals of the drafters and ratifiers of the 14th Amendment, whether there has to be maybe some substantive protection for slaughterhouse-type, Corfield-type private rights or incorporation. I think, and people are going to vary on this, I do think, and again, back to the equality-based reading, that overwhelmingly the thrust of whatever else they thought of the drafters and supporters of Section 1 of the 14th Amendment was to deal with discrimination, and to deal with discrimination with respect to many of those rights that are listed in the first 8 amendments. For example, the differential suppression of different kinds of speech about slavery. That was something we know that they were worried about, that they talked about, and that the anti-discrimination operation, even if there aren't any general citizenship rights, anti-discrimination operation with respect to whatever are the state protections of those rights, which every state had and every state has, will do 90% of what they were trying to accomplish. And that's pretty good for second best.
I learned a lot from the paper. I think it makes a lot of contributions to our original understanding of the 14th Amendment. There's some places I think it doesn't, and I think it's because you're reading the original sources like a legal realist. And I guess the two terms or concepts that were, I think, the paper's off are on rights and on regulation. And for a different perspective, I recommend Philip Hamburger's 1992 article, Natural Law and Natural Rights in American Constitutions, Randy's article in Chicago about the Commerce Clause, and specifically his discussion on regulate, and then, if it may be immodest, work by me on takings and natural rights and regulation in Cornell. Throughout the paper, you keep talking about state law defining rights or state law altering rights, and then when you talk about abridgment and immunities, you talk about a right making a right making the entitlement immune from state regulation. If one is a natural lawyer or a Hardian positivist who accepts that there can be rights independent from state prior to the law, then a right sets a standard or a measure, and a government law can secure the rights. And the case I want to illustrate with is Commonwealth v. Alger, because that was a canonical police case. So at common law, people who live along a bay have property rights on the shoreline, and there'll be some part where the low tide line is, and that marks off their property rights. Boston then made nuisance laws based on the common law lines, and then later they redrew the boundary lines on the basis of above-ground markers that were more visible and more determinate. And for Chief Justice Shaw, that was the state was not creating new rights, it was doing a more effective job of regulating those rights. And if that understanding goes into play for your paper, then state law is not defining rights, or then some state laws do a better job of specifying rights, determining rights, giving substance to rights. Some states' laws protect rights. And then some state laws go and change rights, but those are okay if they do a more effective job of protecting the underlying right than the earlier state law. And then that provides the justification for the distinction between abridgment and police regulation that's in your paper.
John, thanks for this paper. You have an enviable ability to teach as you write, and I've always admired that. And I learned so much from it, so thank you so much. I wanted to make a couple points picking up on this question about the interpolation of the United States and the Privileges and Immunities Clause. As you know, that language comes from the Articles of Confederation. And so I'm interested in whether you think, if in fact that's the correct way to read the Article 4 Privileges and Immunities Clause on originalist grounds, you also think that there was a conception of national citizenship under the Articles, and that clause, should be read in that way too, or if not, whether you think the adoption of the Constitution changed the meaning in just that way, that this is the point in time in which we now legitimately read into that clause the reference to the United States that you mentioned. I'll also just mention this as a side, there are some interesting disputes you might draw upon here. The Articles of Confederation Privileges and Immunities Clause was sometimes invoked in real controversies in a very public way. So in particular, the pamphlet Plain Facts, which is about the dispute between the Indiana Company and the state of Virginia with respect to land. What's significant about that is that pamphlet gets put in front of every member of the Continental Congress. So it goes right to public meaning, and the authors of the pamphlet are invoking the Privileges and Immunities Clause to claim that what Virginia did violated that provision. So I would just suggest that you take a look at that. It might help inform this inquiry. I also want to just ask you about how you understand the legislative power that justified the adoption of the 1866 Civil Rights Act. You passed pretty quickly over the second and third bases that you reference in the paper. So you say some people are going on the 13th Amendment and the enforcement clause of the 13th Amendment. That's understandable. But you also say that there's a contingent in the Congress, apparently, that is referring to both the Due Process Clause of the Fifth Amendment and the Privileges and Immunities Clause of Article 4. But you don't tell us what legislative power they think the federal government has to carry those provisions into effect. And I'm actually wondering if there was a necessary and proper clause basis that's actually the one that you mentioned yesterday. So are they actually assuming that the second necessary and proper clause or some other part of the necessary and proper clause gives Congress the power to carry into effect the implied power of the government to protect the rights enumerated in the Privileges and Immunities Clause and the Due Process Clause? And if that's true, that's a super interesting theory of legislative power that's kicking around in 1866 that I assume would inform the way we understand all of this, and including the deep background of the 14th Amendment. And the last thing I'll say is just sort of a comment on, this goes sort of to something that Eric said about the realist character of the discussion we're having. I just have to comment that I find it remarkable that we talk about monsters and these kind of unfathomable notions like natural rights at an originalism conference. I thought that I wrote a short paper or a comment on something Jonathan wrote, and the title was, "Does Originalism Have a Natural Law Problem?" And I'm thinking now that a follow-on paper would be, "Does Originalism Have a Natural Rights Problem?" Because Randy's an exception, but boy, if originalists can't talk kind of openly and full-throatedly about natural rights, I don't quite know what originalism, how originalism hangs together, because natural rights, as I understand it, is so absolutely central to the way the original Constitution was drafted, understood, and well into the 19th century, including the background to the 14th Amendment. So I'll just stop there.
My question is how we think about the corpus juris in relation to the debate between Iredell and Chase in Calder versus Bull. So one way of thinking about that is that what constitutes the corpus juris that you're talking about depends on the answer to the Iredell-Chase debate. So we're defining it as judicially enforceable law. Those aspects of general law that trump state legislative power when you bring a claim. Another way of thinking about it is that the corpus juris involves a set of principles that not just in political morality, but actually in constitutional law, in the British sense of constitutional law, bind state legislative power. When you bring a claim, maybe you can get that judicially enforced, maybe you can't. See the debate between Iredell and Chase and Calder versus Bull, but we can at least have a way of conceptualizing those principles as part of our constitutional law, maybe general constitutional law, regardless of the answers to the sorts of questions that Michael was pushing on. Thanks.
Thank you. First, Eric, yes, you've identified a moving part, which is the relationship between regulation of rights and abridgment of rights. And two thoughts about that, because this is crucial, and I've been thinking about this for a while, and I'm trying to understand it better. And thank you for helping me. The understanding of abridgment that I'm trying to develop is that an abridgment is an adverse action. You've got me trying to avoid the word change. An abridgment is an adverse action that is not an exercise of power, and again, I'm going to change the formulation a little bit, is not an exercise of power with respect to the legal interests involved. And one claim, and this sort of matches what I think is the structure here. One possibility, and whether this is true would be a question of law, one possibility is that the state government's power with respect to rights, I guess natural rights, is limited to the power to regulate them, to clarify them, to improve them. And if that's true as a legal matter, then that would feed into the concept of abridgment, which, as I understand it, is more of just a receptacle for whatever the law is. And if state legislatures have only the power to regulate rights and no more, then because their authority extends no farther, then abridgment and going beyond regulation would line up. But I think that depends on an independent claim about the law. And one of the important things about the point that within Article 4 and hence within the general citizenship, there is some power in the states to do something. Again, I'm trying to be careful about the words. Some power in the states to do something. Once they've done it, what they've done becomes part of the privileges and immunities. That is, the anti-discrimination rule applies to at least, insofar as they can do it, once they do it, it gets into the privileges and immunities. So I think it's not, for that reason, not possible to define the Article 4 or 14th Amendment privileges and immunities in terms of the possibility that there might be a limitation to reasonable regulation, because whatever power the states have then gets built into the content of the rights. And that way of thinking in particular about Article 4 and the concepts derived from Article 4 leaves open the question whether Article 4 is anything more than an anti-discrimination provision. It is at least an anti-discrimination provision, and insofar as something other than state law necessarily enters into the Privileges and Immunities Clause, the Privileges and Immunities concept, then Article 4 is not just an anti-discrimination requirement, but it is at least an anti-discrimination requirement with respect to the components that of the Privileges and Immunities that come from Article 4. John, thank you, and you're in part you're raising some issues that I want to know some more about, and that I think it is possible to say most of this without knowing the answer to. Because since what I want to talk about is the 14th Amendment, and the language of the 14th Amendment is derived after however many decades it was with Article 4, and with some people saying, and Article 4 has those words interpolated in it, that, and I've sort of indulged the luxury of not trying to figure out on my own what I think about that. And that's why I say that's something I'd like to know what I think is the best answer, but at this point I don't know. And thank you, and in particular, talking about Virginia and the Indiana Company, a reminder of just how important some of those dealings with the Western land companies are to understanding a lot of the Constitution. As for the conversations in the Reconstruction debates and the extent of congressional power, I mean that is something that Judd got into in great depth. Here, I am going to say this, that I think at least with respect to Article 4, I'm less confident of this about the Fifth Amendment, and I think it's important in understanding all this, whenever you see the Fifth Amendment, to think, not the Fifth Amendment as we would understand it today, but just think life, liberty, and property, because they were just talking about life, liberty, and property. At least that, a lot of them were thinking about that. I think that there is a theory that the power that they were thinking about coming related to Article 4 does come out of the second necessary and proper power, because one of the modes of thinking that seemed in 1865 and 1866, the people in Congress supporting the 1866 Act very much seemed to be in, was that they were doing something a lot like protecting their citizens in foreign countries. They were doing, and that's a function of the national government, and they thought they were doing something analogous to that domestically, because they saw the states as hostile sovereigns. Well, they'd just been at war with them. They saw the states as if they were hostile foreign sovereign. And they were acting to secure the rights of their citizens as if they would send a gunboat. And indeed, they did things a lot like that, as if they would send a gunboat. And so I think inherent national sovereignty of a quasi-international kind, and hence powers vested in the government of the United States, probably underlay at least the Article 4 theory behind the 1866 Act. John, yeah, I think you're right, and I think to raise the question and to identify a component of American constitutional, and now I don't know whether to put the word pure in, because exactly Hans Kelsen. A part of American constitutional practice that maybe is not pure law, the kind that a court would work with, probably includes those principles. And general constitutional law in the antebellum period consisted in a large measure of using those principles to try to understand what I am, as a vulgar American who can't even pronounce Kelsen's name properly, we'll call the pure law. And yes, I think that's right, but I think there is a difference between those two parts of the American legal system. Sort of the natural rights as a standard, presumptions. Mike was talking about this. Of course, no free government would take the property of A and give it to B. But I think in order to understand the legal system broadly, it's necessary to see a distinction between the two.
Just quickly, to John McKyle, I don't see a natural rights problem here, and I didn't hear John. I don't think what John said is that natural rights are the monster. I think what he was describing as a monster is this category where we don't even have any examples, I don't think, of a body of rights that arise from neither state nor federal law and do trump and are not subject to state abridgment. That's, as I understand natural rights, they're both, I mean, they have several different functions. The most important is the way in which they are instantiated in the Constitution, both of the federal at the state level, and also as a kind of a backdrop, as they were in Somerset and Rutgers against Waddington, and a few other cases. Curtis in his dissent in Dred Scott uses it this way. I don't think it makes. I don't think anybody's hiding from natural rights.
Yeah, on that score, let me say I'm a recovering positivist. I am trying and have been trying for a while better to understand natural rights thinking, and I call it a monster in that it is for reasons Mike just said. It fits that possibility. I want to identify the possibility. I think identifying the possibility is crucial. The possibility fits with some difficulty in the ways we normally think about the American legal system, the corpus juris, and the American legal hierarchy. But if it's there, it's there.
You know, I understand substantive due process as it evolves in the late 19th century as incorporating natural law, and with the idea that the natural law, also that the Bill of Rights incorporates or reflects natural law. You know, the first right that's incorporated is the Takings Clause. And this is a Harlan decision, Chicago, Burlington, and Quincy Railroad. The requirement that the property shall not be taken for public use without just compensation is but an affirmance of a great doctrine established by the common law for the protection of private property. It is founded in natural equity and is laid down as a principle of universal law. So the substantive due process kind of emerges as, I think, based on natural law, reflects the idea that the Bill of Rights reflects natural law and leads to selective incorporation. It also has both the principle that there's certain things that the states can't do, you know, they can't take from A without compensation. But it also has a room recognition for states being able to do things that vary from state to state. For example, the police power. So Mugler versus Kansas is prohibition in Kansas. Not every state has prohibition, but it's okay for Kansas to decide that it's going to prohibit liquor, even though it destroys an industry. So is that kind of consistent with your conception of what the original understanding of privileges and immunities was in the 14th Amendment? It's just migrated into substantive due process, or is there some difference between that and what you see as the original understanding? I also just want to say, I'd like to talk to you, Michael, about your Rutgers versus Waddington. Dwayne, what you're arguing, I think, is inconsistent with Hamilton. Hamilton is the attorney. I think he has a very positivist view. He's essentially saying we're looking at the Declaration of Independence, and that trumps the state law. And what you're focusing on is Dwayne's kind of avoiding judicial review rather than kind of any principled conception of where they were. But that's a side point.
2 points of information and one conceptual point. So just on vocabulary, in a grayed out portion of our paper that exceeded the word limit, page 37 to 39, we have a collection of all the different formulations of general law, citizenship rights, common law, the general law relating to subjects and citizens recognized by all nations from Wilson, the rights of an American citizen is the common law from Sherman. There are all these different formulations that are there if anybody wants them. On the monster, I don't think we have to look far for an example. So we can look not to Swift versus Tyson, but Watson versus Tarpley, 59 U.S. 517, 1855, where Mississippi said you can't sue on a bill of exchange until after maturity. a local statute regulating the law merchant. And Joseph Story says, well, that's fine. That rule controls in Mississippi courts where they apply local law, but we apply general law, and we're not going to let a Mississippi statute regulate a suit on the commercial law in the federal courts where we apply general law instead of the statute. And that's a recurring feature of some of the post-Swift cases. And that makes me wonder if this conversation about, like, does state law trump the general law, does general law trump state law, might just be asking the wrong question. Like, whether one law trumps another law might depend on who you ask. So does French law trump English law, or does English law trump French law? Well, if you ask the English, they'll give you one answer. You ask the French, they'll give you another answer. So it's right that if you ask a local tribunal whether it's going to apply local law or general law in a conflict, they'll apply local law. But if you ask another tribunal that isn't as bound to apply local law at the end of the conflict, they might apply general law instead. So does state law trump customary international law? Well, if you ask the state court, they'll say sure. But if you go ask The Hague, they'll say no. Does state law trump natural law? If you ask the state, they'll say sure. If you ask justice, it'll say no. And so I think that might just be the state of conflict. And the question is, how does the 14th Amendment feel about all that? The 14th Amendment could come in and say, we're always going to side with state law when they conflict. Or the 14th Amendment could say, we're always going to side with general law when they conflict. Or it could say, well, we'll side with general law, understanding that general law itself yields to state law a lot of the time, but not all the time. But it's more of a choice of law problem than a unitary hierarchy.
My comments are for actually both papers. I'd recommend further inquiry into the meaning of a bridge as used in 1866 or before 1866, and also the meaning of a bridge as used in Section 2. Abridgment is a word, but it may not have much of a pre-amendment meaning or might have a thick one. And the second thing is just on the idea of citizenship in general. I'd recommend maybe using words like fundamental, prior, anterior, axiomatic, cardinal, because those are the words that are used at the time, I think as John pointed out. If the citizens make the states and make the state laws, there are certain things that the states can't do because the citizens are the authors. The citizenry is the author of the sovereignty itself, or participant in the sovereignty.
Thank you, Bill. I wish we had more time for me to say something about the second half of the 19th century and the development of what we now call substantive due process. It seems to me that what happened under the Waite Court was that Miller and Field continued to have what was basically the same argument that they had in Slaughterhouse about, but here it's specifically about rights of property, like in Mugler and Bartmeyer. And Field's notion was an expanded version of no taking the property of A and giving it to B. And Miller's notion was, yes, of course, there's that principle, but it is highly specific. It's not about rules of the common law or anything that general. It's about like the particular glass of whiskey I think he mentioned in Bartmeyer. I think it's by no means an accident that the point on which a majority of the court first came to do what we would call either substantive due process or incorporation was what looked to them like confiscation. And their doctrine about railroad rate regulation in the late 19th and early 20th century is an expansion of the principle that the legislatures can't take the property of A and give it to B, done under the Due Process Clause because people who believed in one thing about the Privileges and Immunities Clause, see Field, would believe something very similar under the Due Process Clause. They thought people had rights, and in particular they had property rights, and that any legislation that directly took away those rights, taking from A and giving to B, was not due process of law because it was legislation and it was not judicial action. So that I think that's what's going on in those due process developments in the late 19th century. Will, on the third point, the question whether all of this is properly seen as a legal hierarchy or as a horizontal choice of law, the set of questions is That's another one I wish I understood. But, and I know I don't really understand it, but I am pretty confident that a legal hierarchy is part of the system. That it's not just choice of law where different tribunals might adopt different choice of law rules and say, well, this is the law in this court, but maybe there's another law in another court. I think it's absolutely necessary to see it, at least in part, in terms of a hierarchy. David, thank you. And I left out Section 2 of the 14th Amendment this time, although it is the canonical example of the use of abridgment with respect to rights having to do with voting in elections that are very much made by the states. And nevertheless, Section 2 says to the states with respect to these rights that you create, and here I'm going to say create and not just regulate, that you create, something happens when you abridge them. And that has to mean something, and what that means is unequal legislation.
All right, thanks, everybody.